Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Daley versus LaCroix. This case was heard in the Supreme Court of Michigan in the year of 1970. Let's go ahead and jump into the facts of the case. Daley's were homeowners, and they're the plaintiffs in this case, and LaCroix was driving a vehicle, and LaCroix was driving this vehicle, veered off the road, flew 63 feet in the air, the case says, 63 feet, struck an electric pole. This electric pole then struck the home of the Daleys while the Daleys were in it. The home was severely damaged. There was an electrical current that was going through it. Everything was shaking, and obviously just the damage of the weight of the electric pole falling on the home. So the Daleys were in there. Both Estelle Daley and Timothy Daley brought suit for the property damages, but they also brought suit for the emotional disturbance and distress that they had experienced. So the court had before itself a case of a negligent infliction of emotional distress. And intentional infliction of emotional distress is different because there is the intention, right? So it's intentional. This is just negligent. The LaCroix defendant, the driver of the vehicle, didn't intend really to cause this emotional distress. It was just negligent. So the court is having this case brought before it, and it has to decide, are they going to allow plaintiffs to recover for negligent infliction of emotional distress? So the court discusses a prior rule that has governed in this arena for a while. It's called the impact rule. The impact rule means that if you're going to recover for NIED, then you need to be struck. Your body needs to actually be physically hit for you to recover for that, right? So you need to actually have some type of physical impact if you're going to claim that you have emotional distress. In the past, the court has said that if you are just like a bystander or you're there and you experience some distress from the negligence, but it is not because of a physical impact, the court's not going to allow you to recover. Pretty early on in the decision, the court says, we're not going to allow the impact rule to govern in our jurisdiction, so they throw that out the window. So what the court is saying is we're going to broaden NIED and not require a physical impact with the actual negligent act for someone to recover for NIED. So court goes on to discuss, how are they going to actually govern this? They say that there needs to be a causal connection. So someone has to prove a causal connection to recover for NIED. So they look at Timothy's evidence, and Timothy, they say, doesn't have very good evidence for emotional distress. He doesn't really look like he suffered severe emotional distress. There was no major expert testimony offered on his behalf, so they say Timothy's claim is gone. Estelle, his wife, however, they consider quite a bit more seriously. They have a psychiatrist testify. The psychiatrist was her psychiatrist from prior experiences. She had had some emotional disturbance and distress and some neuroticism in the past, the court says. So they have this psychiatrist testify. The psychiatrist says, well, this isn't the cause of her emotional distress. It could have flared it up, essentially, is what he says. So the court says, all right, well, we've seen that there is a causal connection between this accident and Miss Daley's emotional distress, so we're going to allow her to recover. So what the court has done in the state of Michigan is extended NIED and not required some type of impact to recover for NIED. They just say that you have to have some type of a causal connection to recover for that. It needs to be a natural result. So it can't be something so far off that it's not a natural result, right? Like your emotional distress couldn't be, oh, I'm your mom and my son got hit when he was driving his car in California. I'm in Seattle. So far, right? It needs to be like a natural result. It needs to be somewhat proximate to recover for that. So the court has expanded the negligence and the ability for people who are impacted by emotional distress to recover. That's the case. There is a quite lengthy dissent by the Chief Justice Brennan, where he talks about how he does not think this should be extended. He does not think that they should do away with the impact rule. And his argument largely is that it's going to increase the litigation brought before the court substantially if there's no impact required for someone to recover for a negligent infliction of emotional distress. So I'll just allow that to roll into the ex ante discussion, which is just going to harp on Justice Brennan's point, which is, if there is no physical impact required for emotional distress, but that person, does experience some emotional distress that manifests itself in physical symptoms, that's probably going to happen quite often. Emotional distress is a part of life. I think it's sad, and it's really sad what happened to Miss Daley here. But emotional distress happens to us in our daily lives all the time. And emotional distress might be brought on by something. It might be brought on by another thing, Maybe Miss Daley was going to have a different experience next week that would have flared her neuroticism, but someone couldn't be held negligent for it, right? It seems like Miss Daley had this underlying neuroticism throughout her life, and that just this experience just piqued it, and now she's allowed to recover for what she had been experiencing as emotional distress and had seen a psychiatrist for her whole life. And I think that it is a little bit concerning to extend the liability as far as they have here, just because while Miss Daley's home might have been a foreseeable plaintiff, Miss Daley might have been a foreseeable plaintiff physically. Is Miss Daley's underlying mental condition foreseeable by LaCroix when they got in this car accident? And I think you can argue very well that it's not. We don't know the mental conditions of each individual and if they're going to flare up by something or another. And it's not as foreseeable as I think the court would like us to believe. And so for that reason, I side with Chief Justice Brennan on this case. And I think that if the court is going to continue to extend liability in NIED, they need to be very careful in doing so, because it is opening up a can of worms in a sense that once you open it, it's very tough to close it. A lot of things are going to get out. A lot of people are going to file suits that wouldn't have existed before, and it's going to it will drown the courts with litigation. I think the argument of the dissent was very powerful in that sense. So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. Hope you have a nice rest of your day. Bye-bye.